Very good evening, everyone, and welcome to today's live discussion on tax treaties and COVID-19 and impact of COVID-19 on tax treaties. Uh, if you really ask me, I think then we can say that this topic is very close to, or in particular, talks about taxation of non-residents. So how this lockdown situation is impacting taxation of non-residents, something which we're going to discuss today. So we have audience to join. In the meantime, I trust all of you are safe. This is Friday evening. You are at home, not doing party. Certainly, if you are in India, you cannot do party out because no restaurants, no bars are open. Everything is closed. Let's see for how long this lockdown is going to continue. Currently, today also the government increased this lockdown till 15th of June. Uh, and God knows, whether it will going to continue even after 15th of June or not. This corona seems, very strong virus. It needs some time to die till, in particular, vaccines, come up to protect us. So thanks to all the doctors who are working, all the scientists who are working in protecting us, in developing the vaccine, and all the corona warriors, whether they are our police officers, whether they are doctors, whether they are cleaners, whosoever is working for protecting us. Salute to all of you. So today, as I said, we're going to discuss impact. So let me open my presentation. Okay, here it goes. Cool. So, as I said, though the topic is tax treaties and the impact of COVID-19, but in particular, what we're going to discuss is the non-resident taxation, how this lockdown is impacting non-resident taxation. And OECD has come up, the Secretariat Office of OECD has come up with a very good piece of document which contains the analysis in April 2020. So I would be using that document as the base to discuss my presentation today. And if you need the document, in the description of this video, I would be putting the link to download the document. You can go to that website and download the document. And if you wish to join me on my Telegram, you can simply, the Telegram link would also be there. You can simply click that link and join my Telegram channel. So whatever the updates I'm sharing on international tax and transfer pricing, you would have direct access to those updates. So let me start with this presentation. So broadly, there are, four concerns point. One is how the lockdown is impacting the residential status of individuals. Second, how lockdown is impacting cross-border workers, or I will say taxation of salaries. Then third, how lockdown is impacting creation of permanent establishment. And fourth, India has some circular notification. We're going to discuss the same. So let's discuss first the residential status of individual. We all know, as far as India is concerned, that after 22nd March, we have lockdown and the flights are not taking off from India. They're not even coming, except where the evacuation happened. Otherwise, all my non-resident friends, they're staying in India. Similar situation has happened across the globe. And generally, you will find that residential status is linked to the number of days. So if you are staying in a particular country for certain amount of days, you qualify to be the resident. And if you are staying for less than number of that days, you do not qualify to be the resident. And if you qualify to be the resident, then your global income generally becomes taxable in that state or that country. Gets a taxing rate which is higher in comparison to if you are treated as non-resident. So, as far as India is concerned, we have a circular number 11 dated May 8, 2020, which specifically give relief to residential individuals as far as their residential status is concerned. So what it says, various representations have been received stating that there are number of individuals who had come on a visit to India during the previous year 1920 for a particular duration and intended to leave India before the end of the previous year for maintaining their status as non-resident and not ordinary resident in India. However, due to declaration of the lockdown and suspension of international flights owing to outbreak of novel coronavirus COVID-19, they are required to prolong their stay in India. Concerns have been expressed that they may involuntarily end up becoming Indian resident without any intention to do so. So, very important assumption that one can see in the circular is that the the individual who stayed in India because of the lockdown is basically intending to move away. But because of the lockdown, he is forced to stay in India, and involuntarily he is ending up becoming Indian resident. So, in order to provide relief to such individuals, we have certain relaxations, and that relaxations are, and these relaxations are only for previous year 1920, that is assessment year 2021. As far as relief is concerned for financial year 2021, we're going to have separate circular, separate notification for the same, which is expected to come once we are through with the lockdown. So the first condition, if the individual has been unable to leave India on or before 31st March 2020, in that case, period of stay in India from 22nd March 2020 to 31st March 2020 shall not be taken into account. As far as the next case is concerned, that you have been the individual has been quarantined in India on account of COVID-19 on or after 1st March 2020 and has departed on an evacuation flight on or before 31st March 2020, or has been unable to leave India on or before 31st March 2020. In that case, period of stay from the beginning of his quarantine to his date of departure or 31st March 2020, as the case may be, shall not be taken into account. Then we have a third case. Now, if he has departed on an evacuation flight on or before 31st March 2020, in such a case, period of stay in India from 22nd March 2020 to his date of departure shall not be taken into account. So, India has given a relief that in certain cases, which we just discussed, number of days, for which you stayed in India, either because of the lockdown or because of the quarantine, will not be considered while computing the residential status of an individual. The another issue which is arising because of the lockdown is the taxation of salaries, cross-border workers. So what happens, when let's say, if you read Article 15 of DTA or even the Act, generally what happens, the salary of an individual is taxable where he works, where the employment is exercised, and then there are certain conditions. So one of the important condition is where the employment is exercised. That is, it is linked to the physical presence of that employee. Now, because of lockdown, let's say, a particular person has stayed in a particular country and he's still getting this salary, very good company. Let's say he belongs to a good company and that company is still paying him the salary, even though he is not working or even though he is working from home, where he has been locked down. In such a case, that salary which he is getting should be taxable to in a country to where his employment belongs, or in a country where he is exercising his employment, that is where he is there because of the lockdown. So this is the issue. Now, generally, this physical presence test is 183 days, and one may have achieved or crossed this threshold of 183 days. As far as India is concerned, we have Section 10(6)(6), which provide short stay exemptions, and that short stay exemption is of 90 days. So, in general, if you'll cross 90 days, then again we can face the problem in the Act. If you'll cross 183 days, then we can face problem in the treaty. So now what OECD model convention says on this, model commentary says on this, we have a para 2.5 of that relevant article, which says, absent facts and circumstances showing otherwise, a payment received after termination of employment as compensation for holidays and sick days related to previous year that were unused during this year should be considered to have been a benefit for which the employee was entitled for the last 12 months of employment, allocated on a pro rata basis to where the employment was exercised during that period. Means, let's say you have worked in an organization for 12 months, now you are on a leave at a particular location and you are receiving a salary. So the salary which you are receiving, because at the time when you are on a holiday or when at the time when you have been terminated, so the salary for that period should be taxable where you are holidaying, or it should be taxable where you exercise the employment. So deriving from this, one can say, because the salary which you are receiving in during the lockdown period is because of the employment which you exercise pre-lockdown period, not in India or not in any other country, but where your employment is there, where your employer is there, in that jurisdiction, in that country, you exercise that employment. And because of that exercising that employment, now in this lockdown period, you may be in anywhere, any part of the world, because of this lockdown period, you are still getting the salary. Now, this is because of the employment that you exercised earlier. So now this payment, taxation of this payment, should also pertain to pre-lockdown period where you exercised your employment. So we have para 27 of the OECD Secretariat analysis, which says exceptional circumstances call for an exceptional level of coordination between countries to mitigate the compliance and administrative costs for employees and the employers associated with involuntary and temporary change to place where employment is performed. The OECD working with countries to mitigate the unplanned tax implications and potential new burdens arising due to effect of the COVID-19 crisis. Certainly, nobody imagined COVID-19 crisis. Nobody imagined that we're going to have a virus which is going to impact whole world. Now, from it is creating for everyone today. Now, creating this no the provision. And now OECD is trying to catch up with all countries. They're trying to come up with a hope I'm audible. I'm sure we're going to see something soon from India also. Now we are moving on to creation of permanent establishment. Because of this lockdown, not only our hairs are increasing, but also extension is the stays are increasing, and this stay or extension may create permanent establishments. So we have para 4 of OECD Secretariat analysis, which says some businesses may be concerned that their employees dislocated to countries other than the country in which they regularly work, and the working from their homes during COVID-19 crisis will create a permanent establishment for them in those countries, which would trigger new filing requirement and tax obligation. So let's say somebody working in Singapore He's an Indian and he traveled to India in March. Now, but because of the lockdown, he's still there in India. Now he's working from home. Whether this guy is creating permanent establishment or not in India becomes the question. So this para talks about the same thing. In general, if I say, there are three broad issues under the permanent establishment. One is, whether home office P that you are working from your home, whether that home would be considered as permanent establishment or not. Now, can we consider you as a dependent agent if you are working, exclusively for your entity? Certainly, one would be. And then third, the impact on construction permanent establishment. So we're going to see each one by one. So as per primary definition, permanent establishment is a fixed place of business through which the business of an enterprise is wholly or partially carried on. Which means if you're working from home, is it a fixed place of business which will create a permanent establishment? And then we have a dependent agent. As per secondary definition, an agent of a dependent status is acting on behalf of an enterprise and has habitually exercised authority to conclude contracts in the name of the enterprise. So if you are working in India for your company which is outside India because of the lockdown, now let's say you are concluding the contract in India. So can we say that you are creating a dependent agent PE? And in case of construction, the lockdown period should be included or not while computing number of days threshold. So we all know that there is a day threshold when it comes to construction PE. In some cases 183 days. So in some cases it may be 120 days. So whatever the threshold which is there in the treaty. So if your number of days are more than that number of days which is written in the tax treaty, then one may create a permanent establishment. And if those number of days is less, then one may not create a permanent establishment. So now, because of this lockdown, that period is coming. Should we include or not? And uh, I think one point I forgot to write also about this decision. Now, because of this lockdown, you may not be carrying the construction contract at all. Should we treat it? Should we treat that activities have been terminated, and one should see it in a piecemeal system that whether particular day before the lockdown, whether those number of days will create permanent establishment or not, and post lockdown should be seen separately, or should we see complete construction contract in one go? So this is another issue which is not written here, but yes, it is there. So let's go one by one. Let's first see creation of permanent establishment through home office P. So we have para 18 of OECD model commentary, which says, even though part of the business of an enterprise may be carried on at a location, such as an individual home office, that should not lead to automatic conclusion that location is at disposal of the enterprise simply because that location is used by an individual who works for the enterprise. So just because you are using, one cannot assume that it will create permanent establishment. Whether or not a home office constitute a location at the disposal of the enterprise will depend upon the facts and circumstances of each case. Certainly, yes. In many cases, the carrying on of business activities at the home of an individual will be so intermittent or incidental that the home will not be considered to be location at the disposal of the enterprise. But I think the important point is this one, which I want to show you. Where, however, a home office is used as a continuous basis for carrying on business activity for an enterprise, and it is clear from the facts and circumstances that enterprise has required the individual to use that location to carry on the enterprise business, the home office may be considered to be at the disposal of the enterprise. So now you are using your home office because the enterprise want you to use to work from the home, or it is because of the lockdown it is necessary that if you need to work from the home because you cannot move out. So there is a difference. Now the current status, you are working from home or the individual is working from home, not because the company wants, but because of the government regulation, because of the restrictions to travel, because of the lockdown, one is forced to work from the home, I will say in this way. So now what para 9 of OECD Secretariat analysis says, during COVID-19 crisis, individuals who stay at home to work remotely are typically doing so as a result of government directive. It is a force majeure, not an enterprise requirement. Very important. Therefore, considering the extraordinary nature of the COVID-19 crisis and to the extent that it does not become the new norm over time, so they are assuming, that things will get back to work. We will all go to office and start working, and it will not going to become the new norm. Teleworking from home, that is home office, would not create a permanent establishment for the business employer, either because such activity lack a sufficient degree of permanency or continuity, or because except through that one employee, the enterprise has no access or control over the home or office. In addition, it provides an office which in normal circumstances is available to its employee. A very valid point. Why you're working, there is a force majeure, there is a government directive which wants you to work from the home, and your home is not at the disposal of the company except you. So, and we are assuming, once the things will get normal, we all will go back to our office and start working. So it is a abnormal situation, and according to OECD Secretariat analysis, it should not create permanent establishment. But yes, what is important? The important is that the government of a country should come up with the clarification. Because if government of a country will not going to come up with the clarification, we might see a lot of litigations. Because the tax offices will take some position, and that position may be pro revenue and not pro SSC, which may eventually go to the courts, and court will take their own time deciding what should be the answer, what should be the correct position, whether to refer OECD or whether not to refer OECD. It may take some time. So better if government, whether it's Indian government or any government, they want to avoid the litigation, they want to support the business, it is mandatory. It is mandatory for them to come with a clarification on various points. Now, the next permanent establishment is the agency P, because that guy is working from home. He may be concluding the contracts. So if he's concluding the contracts, whether that individual is creating a dependent agent P or not, that is a question. So we have para 83 of OECD model commentary, which reads, only person habitually concluding contracts that are in the name of the enterprise or that are to be performed by the enterprise, or habitually playing the principal role leading to the conclusion of such contract, depending upon whether this part is there in the treaty or not, which are routinely concluded without material modification by the enterprise, can lead to permanent establishment for the enterprise. So the word is habitually. So whether this individual who is concluding the contracts during the lockdown position, can we say he is habitually concluding the contracts, or just because of the force majeure, just because of the restrictions, it is becoming important for him to conclude the contract? So what para 11 of OECD Secretariat analysis says, it says an employee's or agent activity in a state is unlikely to be regarded as habitual if he or she is only working at home in that state for a short period because of force majeure and or government directive extraordinarily impacting his or her normal routine. Again, this is the position of OECD Secretariat analysis. OECD Secretariat. It is not the country position. It is not the position of, technically speaking, it is not the position of OECD. It is only the Secretariat analysis. It is must that countries should come up with their clarification, their guidance, which can support the taxpayer. Paragraph 6 of 2014 commentary on Article 5 explains that a P should be considered to exist only when the relevant activities have certain degree of permanency and are not purely temporary or transitory. Paragraph 33.1 of the commentary on Article 5 of the 2014 OECD model provides that the requirement that an agent must habitually exercise an authority to conclude contract means that the presence which an enterprise maintains in a country should be more than merely transitory if the enterprise is to be regarded as maintaining a P, and thus a taxable presence in that state. Similarly, paragraph 98 of 2017 OECD commentary on Article 5 explains that the presence which an enterprise maintains in country should be more than merely, so it's got kind of a repeating, merely transitory if the enterprise is to be regarded as maintaining a P in that state under Article 5.5. So what the conclusion, what we can draw from the OECD is OECD secretary analysis is that there should be something more than temporary. There should be more than temporary. There should be more than mere transitory. There should be it should be habit. It should be habitual. Just because it is happening because of the lockdown, one cannot say that it is creating peak. Now we have creation of permanent establishment, construction P. Now we all know there is a lockdown, there is an increase in period, that whether the lockdown period should be included while computing the construction contract duration or not. In employees case, we have seen that India is saying we will not include. So whether we can apply the same analogy, let's see what para 55 of OECD says. It says seasonal or other temporary interruptions should be included in determining the life of a site. Temporary interruption could be caused, for example, by shortage of material or labor difficulties. Thus, for example, if a contractor started work on a road on 1st May, stopped on 1st November because of bad weather conditions or lack of material, but resumed work on 1st February the following year, completing the road on 1 June, his construction project should be regarded as permanent establishment because 13 months elapsed between the date of his first commencement, first pay, and the date he finally finished, that is 1st June. Basically, this example or this para talks about including temporary interruptions while computing the total amount of threshold. So going by this para of OECD, one can say that one needs to include the lockdown duration while seeing whether the P is been created or not. So the result for an individual and the result for a company for a construction P could be different. So it could again, come up lead to litigation. So the better, I think it is advisable for government to come up with the clarification as soon as possible and not towards the end. Para 13 of OECD Secretariat analysis says it appears that many activities on construction sites are being temporarily interrupted by COVID-19 crisis. The duration of such an interruption of activities should, however, be included in determining the life of a site and therefore will affect the determination whether construction site constitutes a P or not. In general, a construction site will constitute a P if it lasts for more than 12 months, that what we discussed under the OECD model, or more than 6 months under the UN Model Convention. Paragraph 55 of the commentary on Article 5.3 of the OECD model explains that a site should not be regarded as ceasing to exist when work is temporarily discontinued. Example of temporary interruption given in the commentary are shortage of material or labor difficulty. With this, we have already discussed. So what OECD is saying, what OECD Secretariat analysis is saying, is saying that the lockdown duration should be included while computing the total threshold, total number of days on the project. And secondly, just because it is a temporary lockdown, one should not assume that construction site does not exist. And we're going to see the position as a whole. We're going to see when you started, when you ended, including the lockdown period. This is what OECD is saying. Now, the last impact, as per OECD Secretariat analysis, and I am also in agreement with them, is the creation of OM for basically the company plays effective management, because it may happen that certain executives are dislocated. Instead of, let's say, maybe I'm taking example, instead of Mauritius, they are sitting in India, and now these guys are senior, they are taking certain calls from India, Or it might happen that instead of, the guy is not able to travel from India to Mauritius and, take decisions in that country. Now, because of this lockdown, one might have place of effective management of foreign country in India. And if that is the case, that company may become resident in India. So because of lockdown, certain senior executives may not be uh, able to travel, and thus taking decisions from some other jurisdictions. Revenue threshold of we have in India a revenue threshold of INR 50 crores, which means that if your revenue is less than 50 crores, then the poem rules are not applicable on you. So if revenue is more than 50 crores, then only poem rules are applicable. And in such a case, what para 20 of OECD Secretariat analysis says, therefore, all relevant facts and circumstances should be examined to determine the usual and ordinary place of effective management, and not only those that pertain to exceptional and temporary periods such as COVID-19 crisis. Para 21 and 23 of commentary to Article 4 of the OECD 2017 model. Basically, what OECD is saying, that the countries need to come up and evaluate the position, whether, because of this COVID-19, the unusual situation which is coming up, how to support business in this case, how to avoid litigations, how to avoid unnecessary tax filings, how to decrease their burden. So because of this lockdown, everything may get increased. We have already seen that there could be different positions. One, if positions taken by tax authorities are pro-revenue, then the taxpayer will going to face a heat. So it is better to come up with the clarification in form of circular. I would request via this video to my Indian government that, as soon as possible, I think you can always come up with the clarification. Thank you. With these words, let me say thanks to all of you for joining today. See you on Sunday. We're going to discuss a couple of case laws on Sunday. Thank you.